And welcome to the Marion Minor Cook Athenaeum. My name is Sarah Sunbar, and I'm one of the Ath Fellows here. There are many scholars, lawyers, and academics who would agree that part of the beauty of the U.S. Constitution is that it's a living document, and it can be interpreted in light of the current moral, political, and cultural climates. Supreme Court Justice Antonin Scalia, ever the dissenter, would disagree. He once remarked, "The Constitution that I interpret and apply is not living but dead, or, as I prefer to call it, enduring. It means today not what current society, much less the court, thinks it ought to mean, but what it meant when it was adopted." Differences in constitutional interpretation have very real and important ramifications for American civil society and jurisprudence. And critical discussion surrounding the implications of such frameworks is necessary for the growth of our democracy. Our guest speaker for tonight, Professor Jack Rakove, has contributed extensively to this dialogue. He's written several articles and 4 books, including Original Meanings, Politics and Ideas in the Making of the Constitution, which won the Pulitzer Prize for History in 1997. He holds a PhD from Harvard University and is currently serving as a professor of history, political science, and law at Stanford University. This Athenaeum talk is co-sponsored by the Salvatore Center's Lofgren Program in Constitutionalism, and as always, I must remind you that audio and visual recording is strictly prohibited. Please join me in welcoming Professor Jack Rakove.
I have to figure out what the clock is doing so that it may be helpful at an appropriate moment. So it's a great pleasure for me to be able to come back to Claremont. I have various associations here. I have been on campus for different events over the years. My sister was an early graduate of Pitzer College, going back, I say back to the Nixon years, which is how I date my life in terms of different presidencies. And it's a particular honor to be able to give a lecture which is either in honor of or at least consistent with the work of my friend and colleague Charlie Lofgren. I've known Charlie for a number of years. Charlie is, as many of you may know, Charlie is a Stanford BA and PhD. He did his graduate work with my late colleague, Don Fehrenbacher, who was also a Pulitzer Prize winner for his book on the Dred Scott crisis. I didn't have a chance to tell this to Charlie earlier, but I still see Don's widow, Virginia, periodically. We walk around campus. The Fehrenbachers and the Rakoves are all Cubs fans. And whenever I see her, we discuss the current state of the Cubs, which we think has never been better, at least in my lifetime, though. That's why they play the game. Hope springs eternal in the human breast. I have another connection to Charlie Lofgren, which I think is worth talking about in terms of my agenda for this evening. I started thinking about the problem of originalism back in the early 1970s when I was back during the Nixon years, again, when I was a graduate student at Harvard. I didn't think about it in terms of constitutional jurisprudence. I didn't think about it in terms of constitutional law. What I thought about were a set of issues that were before the public in those days. I thought about it in terms of war power issues, in conjunction with the enactment of the War Powers Act, meant to restrict, at least to some extent, presidential war making. Certainly thought about in terms of the impeachment of Richard Nixon, which, being a Cook County Democrat, was the high point of my political life. It was true for many of us. Maybe I thought about it in terms of the draft, because I wound up, because at that time I was an Army reservist, and as an Army reservist, I was a member of a committee known as the Reservist Committee Against the War, led by a guy named Andy Stapp. And I had nothing to do with this, but we filed suit against then Secretary of Defense James Schlesinger, arguing that under the Constitution, members of Congress cannot hold office under the executive branch. And something like 70 or 80 members of Congress had commissions in the reserve. And our argument was, or the argument of the suit was, they had to resign either their seats in Congress or their commissions in the reserve. And I thought, actually, from an 18th century perspective, in terms of the reading I was doing in early American history, I thought that was a great proposition. It really echoed very strongly with a number of things that I think the framers of the Constitution thought. At a point in the history of Parliament, when Americans were convinced Parliament was, the House of Commons was largely a bought-off institution, and the sale of military commissions was a great way to command loyalty, to help build a stable majority in the House of Commons. So I thought on historical grounds, this was a great idea. that was the point when I started thinking about the original meaning of the Constitution. I'm going to say more about how I've thought about this over the years. I know some of you have read some of my stuff, so you may know something about this, but I'll try to fill in some of the blanks and try to elaborate the story. When I got into this field, one of the first people I read on this subject were the essays of Charlie Lofgren. Charlie had written a number of pieces, did one on compulsory military service. He did a piece on the famous and very controversial case, U.S. versus Curtiss-Wright Export Company, which is a 1936 case involving the inherent nature of presidential power. He had another piece on Missouri versus Holland, which is a seemingly obscure case involving the flight of birds from Canada over Missouri, but which actually implicates the treaty clause of the Constitution. So Charlie was an early practitioner of what I'm going to call this evening historical originalism. And I'll explain in a minute or two what that means. All I'm saying is when I started thinking about this problem, the works of Charlie and also his late colleague here at Claremont, Leonard Levy, had a big impact on my thinking. They were kinds of formative examples for a project I started thinking about in the early 70s and only started actively pursuing during the Reagan years after I moved to Stanford in 1980. Now, I think the key thing about this approach, and I think the way Charlie thought about it and the way I've thought about it is, first and foremost, it was not a matter of constitutional law. It was not dedicated to the proposition, how do we interpret the text of the Constitution? It was really more about the question, just how do we think about what a document originally meant? It wasn't an attempt to develop a judicial doctrine of interpretation in the form that originalism now takes. It was simply an intellectual inquiry. If you want to talk about what a document originally meant, what do you have to do? What kinds of intellectual steps do you have to take to try to make sense of something we'll call original meaning? Over time, however, that did become a prominent judicial question, and somewhat to my surprise, it remains so today. It's not clear how much longer this is going to last. The death of Justice Scalia may also be a grave, if not fatal, wound to the doctrine of originalism. I'm not sure that Clarence Thomas can carry the brief on his own authority. But originalism as a legal doctrine may have had a case history. That's really what I want to try to discuss tonight. I'm not sure how long it's going to last, but it's sustained a lot of academic work over the past couple decades, and since there are too many law reviews out there publishing too many articles, it's easy for law professors to keep contributing to this vastly overwritten field. So let me start, I want to stake out three definitions, or at least three modes of thinking about originalism as a judicial project. And then primarily what I want to do is distinguish what I'm going to call historical originalism, the kind of stuff I think I do, from what's also known as semantic or public meaning originalism. And I know some of you, I think, have read about this and have even read a little something that I wrote about it, but I assume that doesn't cover the whole audience, so I'm going to do my best to kind of fill in the gaps and clarify some of the terms. So here are the three introductory propositions slash definitions. So originalism as a judicial interpretation, or let's say as a theory of law, was originally conceived, I believe, as a constraint on judicial discretion. The dominant form of originalism, particularly as it came to be propounded during the Reagan years in the early to mid-1980s, also associated with the work of the late Robert Bork, was largely conceived as a way to force judges to be faithful to the text of the Constitution and not simply to impose their values and preferences and their moral norms upon the constitutional text. And I think the great villains here, for putative originalists would be justices like William Brennan, maybe William O. Douglas, and so on. The idea that, whatever the text of the Constitution said, there might be some moral basis for saying that, normative commitments ought to transcend a textually laden commitment to the original document. So originalism was originally conceived, I think was largely developed, largely deployed as a way to restrain judicial lawmaking, as a way to kind of prevent judges from simply imposing their moral values and preferences on the constitutional text. So that's the first premise we need to have in front of us. That begs the question, what does it mean to be an originalist? If you want to be an originalist, qu'est-ce que ça veut dire? What does that wish to say? What is it you want to try to do? So here I think there are two dominant forms of interpretation. One practiced by a small, but I hope intellectually distinguished minority of scholars, including myself, Saul Cornell, my young colleague at Stanford, Jonathan Knapp. I think Charlie, would align himself with this. One I'm going to call historical originalism, and the other, as I said, is semantic public meaning originalism. So let's try to distinguish the two. Historical originalism, I think essentially is an attempt to say that the Constitution is a document framed through a process of political deliberation where a number of preferences and concerns and objectives and political experiences come into play. And the best way to figure out what the Constitution really meant is to try to reconstruct the kind of political debate that took place, to try to understand what concerns, what objectives, what worries, et cetera, were on the minds of the framers and the ratifiers, the adopters of a constitutional text. So that's what I'm going to call historical originalism. It starts from the premise, which was always my starting premise once I started thinking about this back in the 1970s. If you want to ask what a document originally meant, isn't that inquiry, by definition, doesn't have to be inherently historical in nature? What other form of inquiry, what other form of analysis could you pursue if it weren't historical? What could it possibly mean to say? What did a document originally mean if you did not immerse yourself in the kinds of sources that historians work with? Well, it turns out that there is an alternative form of originalism. Today, in originalist circles, we'd have to go a bit further south. The dominant nest bed or whatever of originalism now is the University of San Diego. It's a very attractive campus, high in a bluff, overlooking, I guess it looks out towards the ocean or whatever. The dominant form of originalism practiced there, and I think it is espoused particularly by Justice Scalia, but also by Clarence Thomas, is what's called semantic or public meaning originalism. And that approach is grounded on the idea not that you want to reconstruct what it was that the adopters of the Constitution or Constitutional Clause actually thought they were doing. The premise of this form of originalism is that you want to come up with the one best linguistic meaning of the clause or provision in question. And the way you do that is you try to imagine or conceive how a well-informed, judicious, hopefully impartial and neutral reader, using the best linguistic tools available at the time, would have understood the text in question. The Constitution, therefore, is a text. It's primarily meant for legal interpretation. That interpretation should be essentially textual or linguistic in nature. You can bring the history to bear, not to explain why the provision is there, but simply as illustrations of the contemporary usage of the terms you care about. I want to make sure you guys see the distinction. The historical evidence is still relevant, but not as to the purpose or point or the rationale or the motives going into the adoption of the Constitution, but simply as evidence of what the language meant. Okay, so three propositions. Originalism as a theory of judicial constraint, a historical version practiced by a small elite group, I call it we few, we favored few, who think that the only proper way to do this is to think historically about the problem, not worry about the jurisprudential implications, but just think of this as a really interesting problem of historical research and interpretation. And then a much more refined body of scholarship, much of it dependent upon work in contemporary linguistic theory, which treats the Constitution primarily in linguistic, semantic, what are called public meaning terms, okay? So those are the three starting propositions. I want to talk primarily about that. That's the real heart of my subject, but I want to toss out a question that maybe we can come back to during the questions, which is I think more is at stake here than simply the question of how do we go about recovering the original meaning of a text. It seems to me that the deeper issue here is how do we think about American constitutionalism? I'll put this constitutionalism either in caps or boldface or with italics or 14 font or whatever. How do we think about the relationship to constitutionalism more generally? What is the American constitutional project about? Is it essentially about producing a text whose ambiguities are resolved primarily or exclusively through judicial interpretation? Or is our constitutional project, let's say the project of forming a more perfect union, does it not have inherently political dimensions? So that for us to be oblivious to the political aspects of what the constitutional project has meant would be to involve not only turning our back on the past, but on the very essence of the American constitutional system. I'll toss this out as an idea. If it's still a bit ambiguous, maybe we can kind of come back and clarify it as we go along. So what I'd like to do now is I'm going to lay out my reservations about public meaning originalism. You know, I'm at the awkward part of my age where I don't really need my glasses to read, but sometimes they come in handy. And I'm not used to, I don't wear bifocals, and I'm not used to doing this, but it might be better. So, you know, a little embarrassing in front of the cameras, but what the heck. So I want to start by identifying, a set of reservations about public meaning originalism. And then I want to go on and talk more positively about what I think historians like myself and Jonathan Knapp and Saul Cornell, and I think Charlie too, have been up to. By the way, Charlie was trained as a historian. So I think it's important to, and he still wears all the appropriate badges and honors appertaining there too. So here are some problems with it. Some ambiguities I have. Number one, I'm not sure who this imagined reader of the Constitution is. Is it a citizen or is it a jurist? Is it an 18th century student of literature? Is it a juror, a lawyer, or a judge? Is this reader a patriot or is he a loyalist? Perhaps it's a she too. Did this reader attend college? Did he, well, here I'll just use the male pronoun. Did he read for the bar? Did he get his political news from the Virginia Gazette? Who is this person we are imagining? If we want to say we're trying to imagine who is this putative, optimal, fictive reader of the Constitution, I don't know who or he is. I did another piece, which I guess I have to make available to you guys, called Joe the Plowman Reads the Constitution. I'm sure many of you remember the character Joe the Plumber from 2008. So as a way of getting this issue, I invented the guy Joe the Plowman as a way of putting, at least giving the guy a name, whoever he is, and wondering, okay, if we wandered to Joe the Plowman's cabin, what would we find? What books would he have? Would he have Fox's Book of Martyrs? Would he have Blackstone's commentaries? Whatever. So we start by saying, I'm a little troubled by the fictive notion of inventing this reader. And the reason I'm troubled by that comes back to this question of judicial interpretation. If we're trying to come up with this putative reader, in effect, we are creating somebody in our own imagination. Now, we may have some documentary sources, to be sure. I'm not saying it's solely a creature of our imagination, as if we were writing a novel in the mold of Fielding or Swift or any other great 18th century author. But there's a sense in which the very idea of coming up with an optimal reader requires a great act of creative imagination on our part. So that's my second point. It leads immediately to the third point. If that is the case, if the reader was not what I call a really existing person in the past, but is the creature of our imagination, how could the idea of semantic or public meaning originalism possibly fulfill the original concern that was at the heart of the originalist project? Namely, to come up with a constraint on judicial interpretation, to force judges to be faithful to some body of evidence that would, limit and influence and help to direct what they're trying to do. If you're a working historian, that's a phrase I like to use to describe myself. It means not only that I'm gainfully employed, that I actually have a job. Also means, what does it mean to be a working historian? To kind of think of yourself as being trained to work your way through some set of documents. The tyranny that historians know is the tyranny of primary sources. If you're a true historian in the best sense of the term, you cannot make any claim that is not adequately supported by some historical text from a really existing living person who occupied some niche in the past. But if you're a semantic public meaning originalist and you're coming up with a putative character, whom you are inventing, it's very hard to see why the linguistic turn would actually constrain you, unless you have very naive assumptions about the nature of language itself. And that leads me to my fourth point. So I hope you can follow what I said. In a sense, far from being a way of constraining judicial discretion, semantic public meaning originalism is really a license to kind of come up with the interpretation that best suits your views. Therefore, it's highly instrumental in nature. And that, in turn, leads to my fourth point, because if there's anything that a historian of the American Revolution knows, above anything else, or anything that the work of the scholarly generations going back to the 1960s, of which I've been a part, have discovered and I think proved, it is that the nature of political language in the late 18th century was highly dynamic. The most basic terms had changing meanings. And these are not trivial terms. For example, what do we mean by the executive power? You know, there are major arguments in American constitutional history about the first sentence of Article 2, the executive power shall be vested in the President of the United States. What do we mean by executive power? Does it include prerogative in the traditional sense of the term, or the Lockean sense of the term, or does it not? What is a, here's another, non-trivial term. What is a constitution? Just read Jefferson's notes on the state of Virginia. You'll understand that the meaning of the word constitution, which I would think is a fairly important word for our purposes, came under a lot of pressure. What is an establishment of religion? These are all dynamic terms, and they're dynamic terms for really interesting reasons, because the late 18th century was a period of intense and deep and highly innovative and highly creative political controversy. And so, of course, we use language not merely to kind of, deploy the best meaning. We always use language in an exploitative process. I don't think we have adequate theories of the nature of political language itself. We don't adequately conceptualize how it is that when we engage in political debate, we're not using terms. We're often abusing, exploiting, manipulating them, and trying to adapt them to our own purposes. So whether or not you agree with that proposition, political language in this period was highly dynamic, was highly creative, came under a lot of pressures, had developed in lots of interesting ways. So the idea, again, that you have a fixed public meaning that's somehow locked into the text of the Constitution, the underlying premise of originalism is that the meaning is somehow locked into the text of the Constitution at the moment of its adoption. That turns out to be a highly problematic notion as well. So to sum up, at least this first part of my lecture, I think I'm actually moving at a pretty good pace here, so I'm not in trouble yet. I guess Sarah or somebody else is going to give me the hook at some point if I go on too long, be that as it may. So I think those are some fairly serious qualms I have about the claims of public meaning originalism. I think one reason why it's attractive is that many scholars are actually too lazy to be historians. But it's not only that they're too lazy, it's that they know that history is not going to give them finite answers. They want to pursue the originalist project, but they're not content with the possibility that it might produce a fair amount of dissonance and noise that would render the very objective problematic. Okay? So those are my criticisms. We can come back, if we have any semantic public meaning originalists in the audience, stand up and you will be duly recognized, at the close of the proceedings. And you will be treated respectfully. I promise you. So now let me try to make the case for historical originalism. I'll start by doing this bit autobiographically. So I started thinking about these issues back in the early 1970s when I was working on the history of the Continental Congress. And then, I had to get my first book out, which is De Rerum Naturam, part of the academic order of things. And then I moved, I taught at Colgate for 5 years. I moved to Stanford in 1980. It wasn't my intended project, but I did want to do one long article to kind of work out what I think of as my method. And it had to do, again, with this favorite subject for Charlie Lofgren to me, the Treaty Clause of the Constitution, about which I thought I had some interesting things to say. So I did a very long article in a now defunct journal published at Harvard called Perspectives in American History, called Solving a Constitutional Puzzle, the Treaty Clause as a Test Case, or something like that. As I started thinking about the issue, I thought, okay, I start with the premise to talk about the original meaning of the Constitution, as I said before, that has to be an inherently historical question. I mean, how else could you answer that question if you weren't thinking in inherently historical terms? But what did that mean? I thought I needed a MO, a modus operandi. And so I developed what I think of as a model. And that's what my book, Original Meanings, particularly the first chapter, which actually Charlie very generously reviewed in the Journal of Southern History 20-some years ago. That's what I set out to do. So let me start, I'll just give real quick, just to give you, the art of my book rests on 3 definitions and 4 categories of evidence, just so you have this by way of background. So by way of definition, I thought reading the existing literature, one had to distinguish the original meaning of the text from the original intentions of its authors, from the original understanding of its ratifiers. The reason I wanted to make that distinction was that as I read the literature, those terms were used promiscuously and indiscriminately, and no one was really concentrating on what each one meant. So a text has a meaning, And one guide to its meaning, that's to say the meaning of the text is what ultimately you want to decipher or uncover. One guide to the meaning of the text might be the intentions of its authors, who would, of course, be the framers of the Constitution. But another guide might be the understanding of its ratifiers, whose sovereign voice was necessary to make the Constitution the supreme law of the land. You guys with me on this? So just for purposes of analytical rigor, distinguish meaning from intentions from understandings. But then to flesh out those definitions, you'd have to do something more. And so that's why I came up with kind of 4 categories of evidence, which I label textual, and 2 textual, 2 contextual. There are 2 textual sets of sources. One would be all the records relating to the intentions of the framers, that's to say Madison's notes of debate and other material directly related to the framing of the Constitution in Philadelphia in the late spring and summer of 1787. Some of you may well know about Mary Bilder's new book, Madison's Hand. Is this a title that means anything to people in the audience? If you're seriously into the subject, it's a book everybody has to read, because essentially it's a biography of Madison's notes of debate, our primary source, and forces you to think much more critically about what Madison was doing than we've ever done previously. It's a tough book to deal with because it forces you to think pretty hard about what Madison was up to. Anyhow, so you start with what the framers did. Then, of course, the Constitution was submitted to the American people for a prolonged process of ratification. Consumed, roughly the better part of a year to get from the opening debates of September 1787 to the ratification by 11 states, every state but North Carolina and Rhode Island by July of 1788. So we now have 20-some volumes with more in the works of the documentary history of the ratification of the Constitution. So it seems to me, so your second set of sources relates to what I call the understandings of the ratifiers. How do the American people read the text of the Constitution? As it was proposed to them, what did they say about it? So there's a big set of sources there. So my definition of intentions and understandings corresponds to this division between the two distinct processes of constitutional adoption. But you couldn't limit the inquiry there. So it seems to me there are 2 other sets of sources that I call contextual in nature, using that term somewhat advisedly, but I think it works. So one would be what I sometimes label the zeitgeist, which is probably a bad joke here, but basically the intellectual inheritance. What was it that late 18th century Americans had absorbed from the voluminous writings on constitutional issues, from the things they'd read, and when they went to college or in the privacy of their studies, or what Madison called their closets, which also meant their studies. The works of Hobbes and Locke and Montesquieu and Blackstone and Molesworth and Trenchard and Gordon and, God forbid, Rousseau, who I still can't stand reading. Montesquieu is important. Maybe Machiavelli, and so on and so on. But there's a rich intellectual inheritance that provides a lot of the background discussion, kind of the vocabulary and the grammar of political thinking. So you'd want to be able to kind of reconstruct that. But also, the second contextual category was, and this is where my life is, the fact that I'm a native Cook County Democrat comes into play, and proud of it, I should add. These guys had just made a revolution. They had a rich body of political experience. They had lots of concerns that were driven by what they had done. They had lots of preferences, lots of objectives that were shaped not by abstract calculations about Republican government, but by their involvement in some course of decision-making. And so it seemed to me what I call the lessons of experience. What kinds of inferences could you draw about their political concerns? If you try to construct the context within which you're working, the intellectual inheritance was certainly important, but since I am also a political historian first and foremost, the record of experience, what had they done, was also formative. So that's kind of my model. 3 definitions, 4 categories of evidence. And then if you try to solve an originalist problem, if you want to turn to a particular clause, let's say executive power or the treaty clause or whatever, you'd have to, or even the Second Amendment. You'd want to sort your way, maybe with a couple adjustments here and there, but that'd be the basic framework that you'd want to have in mind to come up with a historical model. Okay, so that's my starting point. Now, I published that book 20 years ago, April. came back from a term at Stanford, Oxford to learn I'd won the Pulitzer. It's a great experience. It's such a great experience, I've often said this, that you wish it could happen to everyone. But since that's not possible, it's better it happens to you. Except even there, actually, there's a bit of a qualification. There's a little story, but I was up for it's another great book prize I was up for 6 years ago. And it was a strong list of finalists, and myself and Alan Taylor, who's won 2 Pulitzers, and my late friend Pauline Mayer. And Pauline got it, and then died a few years later, actually. Without going into details. That year, in a sense, I'm really happy I lost. One prize is enough. It's great that Pauline, got that one. Good for her, good for us. Anyhow, so I worked out a model, and I developed that in Original Meanings. But since then, I've tried to think a little bit more generally about, not just in terms of my method, but what would a school of historical originalism, what I call we few, we favor few, we minority of originalists, who don't really care all that much about the jurisprudence per se, but do have a kind of intellectual stake in doing the best work possible. What are the leading propositions of this theory? So on this point, I think I have 7 basic points I want to make, and then maybe 1 or 2 concluding remarks, and then we can open it up for further discussion. And some of these things I've kind of anticipated already, so maybe I can do them fairly quickly. So I asked the question, what then are the defining characteristics, or should be the defining characteristics of historical originalism? First, it is not, I emphasize the not, it is not a coherent theory of constitutional interpretation. It makes no normative suggestions as how the Constitution must or should be interpreted. That's a problem for somebody else. That's a problem for jurists. It's a problem for the lawyers who argue in front of them. It's a problem for legal academics who try to prod both lawyers and jurists to do what they want them to do. That isn't, I'm perfectly happy to concede that historical originalism is not the perfect answer for jurists or lawyers. They have a different trade. They have a different set of obligations and responsibilities. They have a different way of operating. And we can't pretend to substitute our judgment for theirs when it comes to actually doing the business of constitutional litigation, which of course is so essential in the end to deciding what the Constitution means at any given moment in time. So that's proposition number 1. I don't want to be overbold about defending, the merits or value of my ostensible approach. Proposition number 2. The essential function of a theory of constitutional interpretation, therefore, must be critical in nature. It must seek to provide a coherent set of methods for discussing the original meaning, intention, and understanding of the Constitution. As such, if it does this, it offers a valid perspective for critically evaluating the merits of legal and judicial arguments that incorporate judgments about constitutional history. In other words, my claim here about being critical is there's lots of terrible reasoning, really, I would say atrocious reasoning, that gets locked into any of a number of judicial decisions, including those by the 8 or 9 eminences of the Supreme Court. And I think one function of historical originalism has to be to criticize, and I mean this in the active sense of the term, to evaluate in a critical frame of mind, what is it that judges and justices are doing. And if they really make a mess of the historical record, which is often the case, and I think actually, Charlie, if we went back to Curtis Wright, U.S. versus Curtis Wright, that would be, a classic case in this ensemble, by anyone's definition. So, but I think, insofar as judges and jurists either want to rely on historical reasoning or just use historical reasoning for rhetorical purposes, which is often the case, it's our obligation and our duty and our positive contribution to say when and on what occasions is that line of argument well done and on what occasions is it highly problematic. If judges are really misusing the history, we should try to force them to reason on better, sounder grounds, right? I mean, not just to use history as a smokescreen or a mask to disguise what it is that they're trying to do. So that's my second proposition. Third proposition, I think, follows pretty directly from this. In this critical function, historical originalism would operate much as historical work does in other realms. And here it's important to think about what is it that historians naturally do. And I'm going to make a point here where some of you may find controversial, but I'll try to defend. This is always where I like to say, thanks, I needed that. The famous movie scene. So if we asked the American public, perhaps if I asked you guys, if we did a poll here and we asked, what is the value of history? Something that many parents ask their, precocious, historically minded children when they major in history at college. The most likely, I don't know how many the young lady over here looks like she's concerned already. Does this ring any bells? And, just tell them it's a lot of fun and you're learning. I've had lots of history students who've done quite well. Like one has been the vice president of Twitter. I think that's probably okay. History did not affect her career adversely. Okay, so the ordinary response would be, well, we study history to learn the lessons of the past, right? We derive lessons about how to behave in the future from observing what's happened in the past. I'm not one of the school of historians who believes. I think many historians will question that. Not all. I think some would agree that. Many of my colleagues would say the past is a story of oppression. And if we study how that oppression took place, we'll be in a better position to correct in the future. That may well be true. I'm not sure I dispute that. But I think the real purpose of history as a discipline, how history operates analytically, is really as much about identifying differences between the past and the present as it is about encouraging people to make too quick an association between past and present. There's a commonplace among historians that the past is a foreign country. And we have to spend a lot of time, things that, I remember reading this someplace, I wish I could find the site, but years ago, maybe probably decades ago, given my age, I read some passage where saying historians could spend years figuring out what the dumbest servant, in a society could tell you in 20 minutes. We have to do a lot of work to kind of come up with the common sense of the past. So the past is a foreign country, and we spend a lot of time visiting there before we feel we're going to be at all comfortable in those surroundings. But the key thing is, I think, is that the whole idea of the past as a foreign country goes to the proposition that while it's important to understand how the present evolved out of the past and try to identify leading factors, leading aspects that would come into play, when we study it for its own sake, it's the difference that we're trying to uncover. It's not the similarity. So in a sense, differentiating our concerns rather than from those of the past, rather than eliding them uncritically or unthinkingly, that's an essential part of what an historical originalist would want to do. So we want to know what were they thinking about. Look, we had a dinner time conversation over here. It goes under the category we call WWMD, which is a variation on WWJD. What would Madison do if he were, plucked out? I actually discussed this with Jon Stewart on The Daily Show in my Emmy Award-winning appearance, as it happens, and I'm not making this up. That's the episode they submitted for their 7th Emmy, so I'm very proud of that too. We talked about having a time machine, but if we could plug Madison out of the past and bring him down to the present and ask, well, what do you think about this? Let's say, what do you think about Donald Trump running for president, to take a non-trivial example? I think Madison was a deeply empirical thinker. There's no point in bringing him out of the past without giving him the same information we have. Right? You can't just pluck him down and say, okay, what do you think of this, Jemmy? There's no point to do that. He has to have the same basis to reason that we do. So I think the idea of recognizing the difference between past and present is a key facet of constitutional interpretation. So that's point number 3. Point number 4, the primary positive purpose of historical originalism is to describe a set of debates involving a diverse set of actors. I want to stress this point. The primary positive purpose of historical originalism is to describe a set of debates involving a diverse set of actors. Those actors shared a common political vocabulary, but their debates encourage them to manipulate and exploit the terms of discussion in rhetorically artful ways. Historical originalists need not concede that every statement made about the Constitution has equal value. They can find ways to argue that some views are more compelling, persuasive, or representative than others. Rather than assume that each debate on particular points end in a consensus on their semantic meaning, we assume that numerous provisions were left open for construction, or, to use a term Madison used, liquidation. meaning would be clarified over time through some process of interpretation and decision-making. This is the language of Federalist 37, which is the text that everybody concerned with these issues has to read, and also, as my mentor used to say about the Virginia Statute of Religious Freedom, memorize. It'll come in handy thinking analytically. This, I think, is a critical point. What historians try to reconstruct, it's so easy for us, actually, I think this ties into the title of George Thomas's first book. We readily assumed that the founders were the founders. They were some kind of corporate collective entity. They were of one mind, et cetera, et cetera. It wasn't that simple. There's a variety of viewpoints. Some were smarter than others. Some argue better than others. Some are manipulative, and others are more engaged in creative thinking. But the key thing is, they were debating these issues. The Constitution did not spring Pallas Athena-like from the brain of James Madison. It was the product of a set of sustained debates in which Madison lost as many points as he won. So I think the real goal of historical originalism is actually to reconstruct a debate, to understand how provisions whose meaning might be contested today arose from this kind of cloudy, complicated, highly conflicted process. And not to kind of oversimplify or overgeneralize or exaggerate the degree of unanimity, consensus that operated among the framers. Fifth, I think, is an extension of this. You guys with me on this so far? There'll be plenty of time for questions. Okay, fifth, historical originalists further assume that the texts we interpret were derived from essentially political discussions involving multiple parties who are not always engaged in direct conversation with each other. Political debate is thus distinguishable from the ordinary conversations that have shaped the linguistic rules that guide the new originalism or semantic originalism. The historian's obligation is less to clarify the distinctive meaning of a clause than to explain the array of potential meanings. I want to stress this point. So, I should have said this earlier. So, if you go back to semantic public meaning originalists, and you look at the works of its leading contemporary theorists, people like Keith Whittington and Larry Solom, Whittington at Princeton, Solom at Georgetown. They rely a lot on the work of a linguist named Donald Grice, taught for a long time, English-born, taught for a long time at Berkeley. There's an attempt to project onto political speech conventions of rules derived from the analysis of conversations between individuals. So if we ask, what is it that language how do we understand language? What is the nature of the linguistic process? What we actually think about the proposition where two people, or maybe a small handful of people, but it has to be pretty bounded, would be engaged in a fairly focused, coherent, circumscribed conversation. That's very different from describing a political debate. And if you want a great example of this, think about the disparity between how Hillary Clinton talks about issues and how Donald Trump fails to respond to anything, or doing how you want to characterize it. But think of the very different, those are kind of different examples. There are multiple forms of political speech out there, right? And so to say you can generalize from rules of linguistics that really are based on fairly intimate forms of conversation to the much more complex process of political speech, which may be conducted within elite circles, but then it's being propounded and laid before people at large. That seems to be a tricky process. And I don't think we have an adequate basis yet for thinking about the nature of political speech as such. I think whenever we think about this, many of us think about, the funny little appendix or whatever to 1984, right? George Orwell's great reflection on, the totalitarian manipulation of language so that truths cannot even be articulated. I don't think we have an adequate definition of how political speech does, and if we don't, we're going to be somewhat circumscribed in this endeavor. Sixth, a compelling theory of historical originalism could assume that beyond the task of imparting meaning to individual constitutional provisions, interpreters need to understand the American constitutionalist tradition per se. This leads to the larger question I pointed out before. Without a coherent set of understandings of how the Constitution was framed and evolved, we will be left with a set of flawed readings that will neither do justice to the content of the text nor address our most compelling constitutional concerns. What's my basic point here? My basic point is to say that the most important provisions of the Constitution were the product of intense political debates. Not just 1787, 1788, but also obviously 1865 to 1868, 1865 to 1870, the Reconstruction Amendments, or you might say the Progressive Amendments too. So if we want to understand what the Constitution originally meant, we have to come to grips fairly directly with the political process that was going on. That's to say, we really have to think, what was the point of the whole enterprise? Was it to produce a text designed for judicial interpretation by 9 justices, or could have been 6 or 7, going back to the original Supreme Court, or maybe 10, which was briefly the case after the Civil War. 9 is nice, 10 is more like playing American League Baseball, and who wants to go that way? You know, if you could avoid, I mean, God meant baseball to be played by 9 players at a time, not 10. That's part of the original design of baseball. You know, we need to have, you know, in other words, what is the American constitutional project about? Was it simply designed to produce a text for judges and lawyers to have fun with as they resolve individual cases, or did it not have larger purposes? Was Reconstruction a second founding, as many scholars would argue? Maybe it was, maybe it wasn't. There's big debates about this. You know, the extent to which, in fact, Bill Nelson of NYU, in his great book on the 14th Amendment, I think makes this case pretty well. There's a strong sense in which antebellum political values remain alive and well, even in the circumstances under which the 14th Amendment was framed in 1866. But the key factor is we have to come to grips with that problem. We cannot understand American constitutionalism if we don't think about its great moments of conflict, its great moments of change, and try to figure out what were the dynamics going on at that point. Seventh point, and really my last point under this rubric, history is a story both of origins, but also of change. By definition, change is what historians study, or as my mentor Bernard Bailyn would say, the basic story of history is how do you get from A to B. A being T sub 1 and B being T sub 2, and some anomaly having to be, in the interim, having to be explained. Now, why is this relevant here? Because the whole premise of originalism holds that the meaning of the text was somehow frozen into it at the moment of its adoption, right? That's what originalism, in a certain sense, that is a necessary fiction or premise of originalism. The meaning of a text is frozen into the text at that point when it's adopted. Now, we would argue, and Charlie wrote an early essay on this that I reprinted. Again, it comes back to the distinction between intentions and understandings. Do we care more about the intentions of the authors or the understanding of the people whose legal votes were necessary for its ratification? And that's fun to talk about. But I think more generally, historians would argue, okay, you write a text, the framer's intentions matter, you get it ratified, so we need to know about the ratifier's understandings. But then, you know, history doesn't stop on the next day. You know, some texts become immediately controversial. Many of you know that the first great debate in the first federal Congress takes place over the removal power of the president. Does the president need the consent of the Senate to remove a subordinate or not? There are lots of really interesting debates about executive power, you know, 1791, 92, 93, down through the rest of that decade, and so on and so on. And the people who engaged in the original process of framing and ratifying also remain engaged in the process of interpretation as it continues, you know, to work its course. So since the historical theory of originalism might say, okay, we need to think clearly and coherently about how do we talk about intentions, meaning, and understanding. What categories of evidence do we use? How do we weigh these different categories of evidence? What importance do we give to each? But we can't freeze the past, and we know the text has been, we know the text has always been under development, always in controversy. I would just say the Constitution has a lot of sleeper clauses. Sounds like a terrorist cell, but it has a lot of clauses that lie dormant. The impeachment clause would be a great example of this, rarely used for our purposes. The House of Representatives is now contemplating the completely zany idea of impeaching the IRS commissioner, and so on. But there's a clause that really doesn't have much history. There are a lot of clauses that lie dormant for a long period, and suddenly they become actionable and therefore controversial. So if you want to be a historical originalist, you also have to remember that you can't end the story simply with the adoption of the text when you know there's this whole process of interpretation that unfolds after that. Okay? So those are my essential rules, and I'm happy to talk about and defend any and all of them against any contender, whoever he or she may be that as it may. But I want to come back to this last point. Do I have a few more minutes up here that I can, am I doing okay? We're about done? Okay, so I'll make this point very quickly. I want to come back to this constitutionalist point. So let me take 90 seconds here. If you want to think about the constitutionalist tradition, a big part of it, and I mean this quite directly, a big part of the American constitutionalist tradition is called the South. What do we do with it? And the reason I say this is another aspect of constitutionalism is its critical moments, certainly in 87, 88, again, 1865, there are questions of regional balancing. There's no question that the history of the South is legally and politically distinct from the rest of the nation. And if we don't confront that fact, and you know, it also plays into our current politics in lots of interesting ways. If we're not open to that fact, if we don't try to deal with the way in which regionalism is a critical element of constitutionalism and the dominant region in terms of the political dynamics really is the South, and what do we do about it? From the existence of slavery through the first and second Reconstructions, and argue on, you know, and into the current state of the polity. We won't have an adequate story. So I hope I haven't bored you in the course of these remarks. I will take any and all questions, and I hope I've made originalism a much more interesting subject than it might have been originally. Thanks very much.
If there are any questions, please raise your hand and Michael and I will come to you with the microphone.
Thank you for coming to speak with us here. I really thought it was interesting when you said that you thought originalism was going to die soon, especially, hopefully respectfully, with the death of Antonin Scalia. But so with an open nomination and two candidates who are unlikely to support to nominate very conservative justices, what do you think originalism's legacy will be on the Supreme Court?
Well, being a historian, actually, I don't believe in predicting anything. That's not the right thing. Take the news one day at a time. And actually, Scalia's death is a great example of this. And I make this quite seriously. I was in Palm Springs, not too far away, on the day that my wife and I were going to an art gallery, and we had an email from my son saying Scalia died. And my first reaction was, this is a reminder of why, I don't say why it's fun, because that sounds inappropriate. But if you're straight out, all of us are going to leave this thing with tears at some point. But for a given individual to die at a particular moment with profound political consequences, that's one of the accidents of history that, you know, that makes doing history so much fun. So I don't believe in predicting anything. And fairly, you know, it seems to me, you know, fairly likely that the composition of court is going to change. I mean, you know, I'm reasonably confident that Hillary Clinton's going to win the election. And I think, you know, I think, you know, for a variety of reasons, and, you know, go to Princeton Election Consortium. It's always a great source for reassurance on this point. So there's a great likelihood we're going to get a, you know, moderate to liberal majority on the court. And I think that's going to have profound implications. I mean, from here, I'm actually going to Washington at a meeting Thursday at a conference on firearms and the Second Amendment. Oh, I'm sorry, I should stay over here. Okay. No, I did that for my hearing, not for my speaking. So if you go to, and I know a lot of you guys have read DC versus Heller, right? So most guys know the case, the Washington firearms case. So Scalia, you know, who labeled himself a faint-hearted originalist, in his opinion, said that, you know, I thought it was rather artlessly, said, well, we might want to have a different regime in place for schools and government buildings. To which my response was, really? Why should you allow security for yourself when the rest of us are going to be made more vulnerable? What kind of disinterested judgment is that? So I think, you know, I'm going a bit afield here, but I think the key thing with the Second Amendment is all DC versus Heller does in the end is to affirm as a constitutional right. I happen to think the decision's wrong, but I don't think it's going to be overturned, that there is a right of self-defense using firearms within the House. I think everything else is open for discussion, Justice Breyer in the McDonald case indicated, I think correctly, that the historical reasoning in DC versus Heller is very flawed. I agree with that 120% or more. So I think that's one area in which, in fact, and probably many guys know, the NRA has lost most of the cases it's brought since Heller and McDonald. That's to say, the attempt to articulate a larger set of what are called Second Amendment rights. I'm very concerned about the use of the plural with the Second Amendment. But, I think they failed there. So I think actually a basis is going to be laid for that. I think its impact in the laws of religious accommodation exemption. I can't remember if I said this. I think I said this at our dinner table. If you know the Zubik versus Burwell case, Scalia had been on the court. This is the case involving. It's a case of people on the right wish were called little sisters of the poor, rather than Zubik or Zurich, whatever his name is. It's a case involving the checkoff provision. If you're a religiously scrupulous institution, you don't want your insurance to pay for contraceptive/abortifacient procedures. The question is it really wrong for you to just tell the government you're not going to pay for it, so some other means of payment will be generated by your insurance company? Scalia around the court, that most people I've talked to think that the majority would have ruled with the objectors, with the plaintiffs, the Catholic and Baptist institutions. With the liberal on the court, I think you're much more likely to rule on behalf of the women, who are actually the real beneficiaries and decision makers there. So yeah, there's a whole array of cases out there. And again, the idea we're going to have a conservative court, to use a Hebrew expression, Vidor Vador Le'Lem Va'ed, from generation to generation, forever and ever. That's I don't think that's going to stand up. So it could be a good time to be a Supreme Court historian, because there may be a lot of changes maybe in the works.
Yeah. Hi there. Thanks for your speech. It was great.
I'm happy to be here.
Thank you. So am I. My name is Jack Sohn, and I was curious. So when you're looking at historical originalism versus like Scalia's more like semantic originalism, in historical originalism, is the text largely symbolic, and how does historical originalism handle cases perhaps where, this would be a weird example, but there's a malintent on the behalf of like the framers or something like that, where their intent doesn't align with necessarily the words they're actually writing, and the words they're writing represent something to the common readers at the time, that is a general educated reader, sort of where the semantic originalists would sort of propose. And an example of this would be something like Animal Farm, right, where it says all animals are equal, but sort of implicitly and perhaps in the intent but some are more equal than others.
Yeah, this is where I'm trying to say block that analogy. So if I followed what you're saying, I'm not 100% confident I did, but in a sense, since I am at Claremont, part of me hears the idea of, is there an esoteric reading the Constitution under kind of quasi-crypto proto-Straussian grounds? They might say the framers had one set of motives, but the language of the text somehow disguises what they were up to. Maybe you can clarify this.
I'm not exactly saying our particular framers had this sort of quasi-intent. Yeah. For example, like this is in the Declaration of Independence or something like this, right, where they put all men are created equal. Right. Looking at exactly what their intent is a pretty messy historical, maybe, as a historian,
actually,
you would
I don't think
more.
so, but go ahead.
Okay, all right.
Yeah.
I'm not trying to pick a fight here.
No. It's something I've written about, so I actually.
Okay.
Yeah. So here's my answer. I think this will work for your question. So when Jefferson wrote, "All men are created equal," if you look at the whole structure of, I know there's been a big issue here at this institution over a long period of time, really so off and on. Jefferson's primary concern was not to make a universal statement about individual equality, or not to kind of lock that into the meaning of the Constitution so that later generations would unpack and uncover it and start to evolve it. The whole point of the preamble, whatever, however you want to characterize it, to the Declaration, the opening passage of the Declaration, was to say that Americans as a people had the same collective right to self-government, including the right to alter and abolish government under certain conditions, bring John Locke into play, that other peoples had. It was not a statement about individual equality. It was not meant by Jefferson or I think any of his contemporaries at that moment, given the context in which they were operating, to come out with that kind of radical dimension, aspect, ambition of the American project. But so what? We know over the course of time, and I think this story is as much true today, but it's also true, let's say, back in the 1810s and 1820s, that increasingly, from decade to decade, people started to read that clause, wholly independent of Jefferson's intention, as a statement about individual equality. That's what I like to say about it. That statement has a corrosive quality, and when I say corrosive, I don't mean it's corrosive of itself. It's corrosive of all other institutions. Once you accept equality as a norm in one realm of behavior, how do you confine it? How do you prevent it from infecting or relating or shaping your perceptions of others? Once you make equality, just in a general sense, a guiding principle, to use our current language, lots of other applications remain to be discovered. And I think you could tell a great story about American constitutional culture, which was started. In fact, actually, I'm going to start work this year. It's just actually going over my contract here for a book I'm calling The Ticklish Experiment, A Political History of the Constitution, which is actually a book that no one's tried to write. It's kind of curious to me. There are a lot of histories of different facets of the Constitution, but no one's ever actually tried to write a one-volume interpretive narrative history of the Constitution. I hope Charlie will agree with me on this. If you could think of a volume, I'd like to know what it is. And a part of this, I want to have, so one theme here is I want to talk about what we might call constitutional culture. It's a different constitutional law and called constitutional culture. It has to do with the development within the polity, that's to say among the citizenry, of some set of norms and behaviors and attitudes and so on and so on. And I think the commitment to equality is dynamic in that way. No one would, very few people would have said in 1776, and certainly Jefferson would not have said, well, I'll qualify this, I'll say it then I'll qualify it, that this really applies to African Americans. I mean, Jefferson did not mean that statement per se to be an indictment of slavery, though of course so many people afterwards read it that way. Curiously, when Jefferson writes the notes on the state of Virginia, when he refers to the bill he wrote but never introduced, that a bill for gradual emancipation, it has that very controversial, because it's in many ways racist, passage in Query 14 of the notes, explaining why blacks should be freed but then colonized. He uses the language of the Declaration. He says, "We shall declare them a free and independent people." He wants to give freed African Americans the same status that he was claiming for American colonists, free American colonists, back in 1776. So in a sense, Jefferson inflects, or kind of through a process of contagion, affects his own language. I mean, I hope that answer is responsive to your question. So I see it. There's a question about what's the best reading of the document at the moment of its composition, but then, this is where the whole business of the understanding of the ratifiers, or understanding of later citizens. But texts, once they're published, are open to interpretation. They're also open to what I said previously, also open to processes of manipulation and preemption. So it may not be what Jefferson said, but boy, I really like his language. And you know what? Here's a place I think I can make it work. That's how political speech works. You take something that's out there and you look for ways to manipulate it. And that's different from being perfectly objective, or as fair-minded as you can be about recovering its original meaning. It's an ongoing process.
Hi, thank you for your talk. My name is Naveen, and I just had a quick question about, you talk about historical originalism and being mostly from the judge's perspective and also considering jurors or citizens. I wanted to know, other lawmakers such as executives or legislators, do they utilize originalism as well? And if so, I was wondering if you can comment on what other government individuals do.
I mean, congressmen may speak in those terms, but given their lack of individual responsibility, it's hard to make one sense of it. I don't think it matters that much in the executive realm, because there, I think the imperatives of decision making are so strong. You have that you can't really reason on those grounds. But I'll tell you a funny story. So about 20-some years ago, when I was working on this book, working on original meanings, sometime back in the mid-'80s, there's something at Stanford we called, I think, the Humanities Forum. It's a group a bit like this, except it's actually made of, income-earning adults who we hope would, provide financial support for the study of the humanities. And so one evening I was asked to give a talk on originalism. So when I just started working on it, must have been like 85, 86. And the commentator was Ed Meese. Do you guys know who Ed Meese was? Not the adults, the kid. You stop nodding. The kids in the audience. He was Reagan's Attorney General. He's still affiliated, I don't think he's in good health, but he's still affiliated with the Hoover Institute at Stanford. And Meese was Attorney General at the time when the conservative intellectuals in the Office of Legal Counsel, I think it was called that then, were developing their theories of originalism. And Meese gave a famous speech in 1984 calling for a return to a jurisprudence of original intention. Justice Brennan gave another speech some months later. It wasn't meant to be a direct response to Meese, but for all intents and purposes it was, which criticized that position. So Meese had a group of conservative intellectuals around him, who were very interested in articulating this theory under the premises I laid down earlier as a way to criticize kind of Justice Brennan type jurisprudence. So I made the point that, which I think is true, that many of the claims for executive power made today, and this again during the Reagan years where, there's big disputes over, particularly over the Contras, American policy in Central America was very controversial at that point, and the administration was trying to do all kinds of things to circumvent the Bowling Amendment and other congressional restrictions. So eventually led to the Iran-Contra controversy in 1986. So I made this argument, which I think is true, that in fact, the foreign policy powers of President, contra Alexander Hamilton, the great hip hop artist, were not, we're not nearly as broad. We're not endowed with as deep a notion of prerogative as many contemporary people said. And his response was, he says, you have to remember, a lot of time has passed since the 18th century. And we live in a very different world, so we can't really be bound by, whatever they were thinking then. And, I'm perfectly fine with that. I mean, again, I'm a historian. I think history's a story of change, so I don't have any problems with his description of what had happened. I just felt, but if you think that about the realm of executive power, then why not the realm of jurisprudence? And what is it that makes judges uniquely responsible? To be faithful to past. After all, judges are supposed to exercise judgment, which means they have to choose among an array of criteria and considerations, to reach a decision. So why should they be time-bound in a way that other branches need not be? I thought it was a good story. I hope you guys appreciate its humor.
We will have time for one last question.
Oh, come on. Hit me with your best shot.
Hi, my name is Gabe Luskin-Braun, and I was wondering, given how you talked about how the differences between now and the time of the founders and all those and all the people writing at that time is important in understanding those documents, and given how the Declaration of Independence and the Constitution are so ingrained in our culture today and our pride in the nation and our patriotism. What do you think about how we can take those writers and those documents as a part of our cultural identity today?
Well, it's a pretty open-ended question. I have a very general answer to it. It's less about the documents than about the experience. I think the American Revolution was a great event. I say that not only because I've made my career, on the basis, I flourished or whatever as a scholar the last 40-some years by writing about it, but I truly, deeply, honestly, sincerely believe it's one of the great events in world history, notwithstanding all the problems that we have with it today. And it's a world that accepted slavery as something that's only starting to become somewhat objectionable. They accepted all kinds of gender differentiations and class differentiations, so on and so on. But, I think, it's a great question to ask. Here you have, to use the language of my mentor, this provincial backland, marshland, a provincial backwater, 3,000 miles away from the beating pulse of Enlightenment culture and European civilization. And yet, when the revolution breaks, in the mid-1770s, and then when it's reconsidered in the late 1780s, these guys did a lot of really creative thinking under very intense circumstances. And while there are different aspects of the Constitution you can object to and so on, the number of problems they raised, the number of solutions they imposed, I think it's quite impressive. Now, I'll give one example that really strikes me. I think it's really the case if you look at the so-called European constitutional project. Or even think about the Brexit vote or the vote for Scottish independence. And, 50 years ago, in 2 weeks is when I met my wife in Edinburgh. So I have very fond ideas about Scotland. You think about the process of constitutional ratification, what the Americans did in that period from September 87 to July 88. It's really quite incredible. I mean, without any working precedent, and with lots of kind of somewhat nutty, zany things being said at the margins, Americans engage in this really wide-ranging debate about forming a constitutional government. And they come up with a decision that was clean and unequivocal and gave complete legitimacy to the political system they were creating. If you look at the Europeans, if you go back to the European Constitutional Treaty of 2003, or you look at the Brexit vote. So Brexit, I think, is a terrible, big mess. It's hard to know what's going to come of it. But, a lot of people voting for it did so, not because they're really focused on what Brexit was going to mean, but out of an animus against immigrants. Back, if you look at some of the rejections of the European Constitutional Treaty, going back to, the early years of the previous decade, same kind of process was at work. What should have been properly framed as a decision to be taken in its own terms got equated or conflated with these other issues in a way that was adversarial to the process you're trying to promote. So I go back and I think about it without having any precedent at all for how do you adopt a national constitution on the basis of a public deliberation in 13 different states to look at how well the Americans solved the problem. That's quite an achievement. And I think, even though I don't think history is really about learning lessons, in this case there might be a lesson or two to be picked up from the matter. So thanks a lot. It's always good to come down to is this the Inland Empire? Is that where I am? The Inner Empire, whatever it is. It's always great to come back to the Southland. Thanks a lot.